Hi, Tim Blanchett with Divorce661.com. Today we're talking about alimony and spousal support in California, and specifically the state of California Franchise Tax Board put out a publication talking about spousal support and alimony, and we're going over a lot of the questions, getting this recorded on video so folks can have a better understanding of how this works. And we just shot a video and it was talking about what types of payments do not qualify as alimony. And we went through 3 or 4 things the Franchise Tax Board talked about here. And one of them was this, that is not does not qualify as alimony. Any voluntary payments made before they are written by a divorce decree or written agreement. So right now we handle about 50 divorce cases a month. We do a high volume because we have affordable flat fees. And we do really good, do a really great service for folks, taking care of the entire process for them from start to finish anywhere in California. So we see a lot of scenarios in divorce. And what a lot of people do is they file for divorce. They either will move out or not. Maybe they'll stay in the residence, just for financial reasons. But they're doing one of 2 things. They're the one maintaining the status quo and continuing to pay the bills and keep everything going as it was until they finally get to the point where they divide up their property and come up with spousal support numbers if that's the case. Or let's say one party moves out and let's say the spouse that was working and let's say the other spouse wasn't, they start giving a couple $1,000s a month or whatever is appropriate in their case. They start paying an amount to be considered as spousal support and child support. Well, from what this says, that would be considered a voluntary payment and would not qualify as alimony or spousal support in California. And the reason that's important to note is if you are paying money and there's no court order and it's not considered alimony, it's therefore not tax deductible. And that's one of the biggest things with alimony is you can deduct that from your taxes. So if you pay $2,000 a month in alimony, and you have a court order that says so, then you can deduct those at the end of the year, and your spouse receiving the spousal support would have to include that as income, and they will be the ones paying the tax on that. Now, the way you can circumvent this to make sure you're not getting that tax advantage is as soon as you separate, call us. We can put together what's called the stipulation in order. So if you're going to pay $1,000 a month or whatever that number is, say, Tim, I'm paying $1,000 a month. The divorce isn't finalized, which could take 6, 8, 12 months, depending on how fast you move through the process. You're going to want to get some temporary orders immediately, especially regarding alimony, so you can get that tax advantage. So you're not just writing checks that you're not going to be able to get any credit for. So this was right directly from the Franchise Tax Board. We're not tax advisors. We're not giving tax advice or legal advice. But I wanted to get this out there because this is how the Franchise Tax Board and the taxes treat alimony. So get that court order as soon as possible so you can take advantage of those payments being considered as spousal support and alimony. Tim Blanchett, Divorce661.com. We can put an order together for you as soon as 24 hours. We also can handle your entire divorce case anywhere in California. Thanks for watching.